A special thank you to each of our subscribers who make this channel possible. Here's today's story. The U.S. Supreme Court has agreed to hear a pivotal case that could reshape the landscape of environmental regulations across the country, particularly regarding California's ability to set its own vehicle emission standards. This case tests the limits of federal authority versus state rights, specifically through the lens of the Clean Air Act, which has been a cornerstone of U.S. environmental policy since its inception in 1967. The case revolves around California, often dubbed the golden child of environmental regulation, which has been allowed to establish stricter air quality standards due to its unique pollution challenges. With the largest number of vehicles in the nation, California's air quality issues are both acute and persistent, prompting the state to take proactive measures to combat air pollution. The Clean Air Act originally permitted California to implement its own vehicle emission standards, a decision made in light of the state's dire need for tailored regulations that exceed federal benchmarks. This provision has allowed California to enact over 75 waivers since the law was passed, enabling it to lead the charge in environmental protection. However, tensions escalated when the Trump administration revoked California's waiver in 2019, prompting the state to challenge this decision in court. After President Biden took office, the Environmental Protection Agency, EPA, reinstated the waiver, reigniting the legal battle. Now, Ohio and 16 other Republican-led states have filed a lawsuit against this reinstatement, claiming it undermines the constitutional principle of state equality. They argue that the waiver gives California an unfair advantage, allowing it to dictate national policy on vehicle emissions. This lawsuit is not just about California. It symbolizes a broader struggle over environmental policy and state versus federal authority. Environmental advocates have criticized the lawsuit, asserting that the Republican states are not genuinely interested in adopting similar standards, but rather are attempting to dismantle the Clean Air Act altogether. The D.C. Circuit Court of Appeals sided with the EPA, ruling that the Constitution does not prevent Congress from granting different levels of authority to states based on their unique circumstances. This ruling has now been appealed to the Supreme Court, which will determine whether the industry groups challenging the waiver have the legal standing to sue. The Supreme Court's decision will have significant implications not only for California, but for the future of environmental regulation in the United States. If the court rules in favor of the challengers, it could set a precedent that limits states' abilities to establish their own environmental standards, potentially rolling back decades of progress in air quality and climate change mitigation. Conversely, a ruling in favor of California could reinforce the state's role as a leader in environmental policy and uphold the Clean Air Act's provisions that allow for state-specific regulations. The stakes are high as the nation grapples with the urgent need for climate action and the role of states in shaping that response. As this case moves forward, all eyes will be on the Supreme Court, where the justices will weigh the arguments of both sides and ultimately decide the fate of California's emissions standards and, by extension, the future of environmental policy in America. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.